Hello all, this will be my final video on the process of trying to get your house back. As mentioned, my channel is called AI Gaming and Technology, AI being my initials, nothing to do with artificial intelligence. I want to focus on gaming and technology, so every time I do a video which is not related to gaming and technology, such as this one, I'll try to upload a video that is related to gaming. So in this case I've uploaded some videos on Daytona USA, probably my favourite racing game in the arcades. Go check that out if you'd like. Right, now let's crack on with the process for evicting your tenant. So with previous two videos, first one was on section 21 and all the documents required before you could issue a section 21. Second video, which was quite long, was on the accelerated possession form, also known as the N325 form, and the list of documents you need for that. Now, after you do the N325 form, the court will then contact you. This is what they will send you: a notice of issue. So the N325 was done on the 28th of January 2025. This letter came shortly after the N325 form was sent to the court, and as you can see, we're just going to go through it. You can see it has the landlord's name and details there, claim number, claimant, defendant, and the amount that was paid. As I said, this is now higher. It was 391 when I did it. It's, I think, currently 403, and it's going to go even. It just will get higher and higher. Now you can see here your claim was issued on 30th January 2025. The court has not yet served the claim on the defendant. When it does so, it will send you a separate notice of service. The defendant has 14 days from service to file a defence. If a defence is filed, the court will send you a copy. If the defendant does not file a defence, you may ask the court to make a possession order and, if applied for, an order of costs. Complete the tear-off portion of this form and return it to the court office. On receiving either the defence or your request for an order, the court staff will refer the claim to a judge to decide whether or not to make an order without a hearing. You have 3 months from the date by which the defendant should file a defence to file your request for an order. If by then the court has not received either a defence or your request, the claim will be stayed. There's some small print here, and you can see here that this is the part you've got to tear off and fill out, inevitably when your defendant still does not leave. So you can see a request for possession order and costs. I'll come back to this this form, and you can see here the details, claim number. Again, I've made these up. Claimant and defendant. So you can see here the defendant has not filed a defence to my claim, and the time for doing so has expired. I asked the court to order the defendant to give me possession of the premises and to pay my costs. As mentioned previously, you'll be lucky to see a penny. The objective of all this is just to get your property back. The fact that the court order the tenant, the defendant, to pay your costs is almost irrelevant, because you will see not one penny. So once the court has served the claim on the defendant and the 14 days has expired, you can then fill this request for possession order and costs slip out. You can cross this section out, which is what we have to do in our case. Sign it and date. All you got to do is just literally sign it and date it and send it to the court. When you do that, you will then get another document returned back to you. I'll show that shortly. So once you've filled out that little slip on the first document I showed you, you will then receive an order for possession. This has obviously the details of the landlord, the claim number, the claimant, the defendant, the date. Now this letter is good news, because it then gives you a clearly defined date set by the judge for the defendant to leave your property and hand over possession. Surprise, surprise, they won't do it. they still will not hand your property back, even though you've got a order for possession from the judge. They still won't do it. Let's just go through this very briefly. Warning: you must comply with the terms imposed upon you by this order, otherwise your case is liable to be struck out or some other sanction imposed. If you cannot comply, you are expected to make a formal application to the court before any deadline imposed upon you expires. So even though this was issued dated 28th February, it was actually issued on the 26th of February, a couple of days before. Deputy District Judge Bison, obviously I've changed the name, sitting at the County Court at Chelmsford Justice Centre, Prior Place, New London Road, Chelmsford, Essex, CM20PP, read the written evidence of the claimant and the defendant, and the court orders that the defendant give the claimant possession of your rented property on or before 12th of March. So now there's a clear date for when the tenant should leave and give the property back. They won't, and I'll go through what you have to do when they inevitably do not leave. They, as I said, they'll just make it a drawn out, long and difficult as possible for you. But we have a date here of 12th of March. The defendant paid the claimant costs of £391 on or before the 12th of March. So the acquaintance paid £391, and it's now been deemed by the judge, or ordered by, I should say, it's been ordered by the judge that the defendant should pay the landlord £391. You're not going to see any of that. That money's gone. Note: this order is made without a hearing. Within 40 days of it being served, either party may apply for it to be set aside or varied. Right. To the defendant, which is obviously your non-paying tenant, the court has ordered you to leave the premises by the date stated in paragraph 1 above. If notice attached of a hearing to consider your request to remain longer, the date you must leave may be varied at the hearing. If you do not leave by the date fixed by the court, the claimant can ask the court without further hearing to authorise the bailiff to evict you. That is usually the case. As I said, 999 out of 1,000 times, the tenant will wait and wait and wait until they are physically removed by a bailiff. Payments should be made to the claimant, not to the court. If you need more information about making payments, you should contact the claimant. Kiss your money goodbye. You're never going to see your money. Just the aim is get this nuisance tenant out of your property. As you can see, we have the details of the landlord here, and if you don't pay the money owed when it is due and the claimant takes steps to enforce payment, the order will be registered in the Register of Judgment, Orders and Fines. This may make it difficult for you to get credit. Further information about registration is available in the leaflet, which you can get from any court office. So you could attempt to go after the tenant and try to get your money. Oh my goodness, good luck to you, because I've never known any person to be successful from that. But yeah, I'm sure it has happened, but good luck. Right, and then there's some small print here, and this is the order for possession. So inevitably the date for the 12th of March came and went, and of course, you know, as usual, difficult tenant did not leave. So what do? You would do the following. Right, so the defendant hasn't left. Surprise, surprise, they're still at your property. So you have to now fill out a form, which is a warrant of possession of land. So this form here is a request for warrant of possession of land called the N325 form. So relatively simple form to fill out. There are a couple of things which are maybe a little bit tricky, but we'll go through it. It's literally one page. It's not too difficult. So you just put your claimant's name and address, which is obviously your name, your home address, and your postcode, and in this box just put as above, and your phone number in case they need to contact you. Here you'll put your tenant and your rented property, which you're trying to get back. The fee, which was £391 for the original N5B form. The fee for this, again, another proverbial slap in the face, is at the time this was done, it was £143. I have no doubt it's more now. So you put all the figures here. So the 391 amount for the warrant to be issued is 391. The issue fee 143. Add it all up, 534. We have no legal representative cost, no land registry fee. So the N5B form, the amount, again, same here. issue fee total amount, which is the 391 add the 143 is 534. Date of the judgment order, which was, as I showed previously in this video, was 26th of the 2nd 2025. Date of possession should have been 12th of the 3rd, but obviously they did not leave. And we write a short description of the property, very simple. Just put the address, and you just put which is a residential house. That's all they need. Just a very simple, short description of the property. It's just here's the address and it's a house. Up here we'll put the court, so it's in the county court at Chelmsford Justice Centre. The claim number. We don't have an account with them, so leave the fee account number blank. Warrant for court use only. Warrant number, you leave this all blank because obviously it says for court use only, so leave that blank. Now here you cross section 2 out and leave section 1 as it is. The defendant has not vacated the land as ordered, and that the whole or part of any instalment due under the judgment or order have not been paid, and the balance now due is as shown. As I said, you're not going to get any money back. We just want this dreadful tenant removed from the property. You will go to the bottom and you will just put your phone number, again phone number, your contact name, which is obviously the landlord, Mr. Chung Lee, and if you have it, you can put the defendant's phone number, which obviously you more than likely will have the tenant's phone number because you should have taken it when you first gave them the AST. If you have any information which may help the bailiff, or if you have reason to believe that the bailiff may encounter any difficulties, you should write it below. So we left that blank because there was nothing really extra to put down. So this is the N325 form, excuse me, the N325 form. So you fill this out, then what do? You have to do another cover letter, which I'll show you now. So when you fill out the N325 warrant for possession of land, you can do a cover letter. Again, just copy this, claim number, put it here, the court details you put down as well here on the left hand side, the date, so they should have left on the 12th of March, which they did not, so literally the next day, Thursday 13th of March, I did this paperwork. Again, dear sir, madam, ref N325 form for warrant claim possession of land, property address, this is your rented property you're trying to get back. Again, I called the court and the lady kindly informed me to put my phone number in this letter so that you can call me to take payment of the £143 and then put your telephone number there. So once the court has your cover letter along with the N325 form, they will call you and you pay the £143, which is obviously gone up now, I would imagine. Along with the N325 form, give them a copy of the possession order, which I showed you earlier. I'll pull up on the screen again now. So again, when you filled out the N325 form and you're doing your cover letter, you provide the cover letter, the N325 form, and give them a copy of this. So just put this in with your cover letter and your N325 form. Right, so please find and close N325 form along with copy of possession order dated 20th February 2025, but it was issued on 26th February 2025 with the date for the defendant, Mr. Ken Masters, to give back possession of my property on Wednesday 12th of March 2025. I'll be most grateful if you could give this matter your earliest attention. Please forward any correspondence to my home address of and your details here, Miss Chung Lee, and the address. Thank you very much. Yours sincerely, Mrs. Chung Lee, the landlord. So you've now done your N325 form. You've sent that off along with the order for possession and the cover letter. What do you do then? Well, once you've done that, what will happen is hopefully you'll receive further correspondence from the court, and it should be a warrant for possession of land, which I'll show to you now. So now that we've done the N325 form along with the cover letter and sent that to the court along with the order for possession, they will then hopefully send this back to you, which is a warrant to be issued. So you can see here, please note the following warrants were issued on the 18th of the 3rd, so quite quickly from the date of the letter, and will be executed in the court listed below. When contacting and executing the court, please quote the issuing court's name and the warrant number allocated to this case. They will put your details here, they'll put the date that it was issued, they put the court details, you have your case number and the warrant number. Again, I've made these up, the defendant and the court details. So this is your warrant to get your property back. Now, what happens then? I will show you. So when you receive the warrant, what will happen then is the court will, in a few days' time, send you a notice of appointment with the bailiff, also known as the EX96 form. So here is the form here. Again, I've changed the details so that just so you have a full example, made up details. Here we go. You can see the details of the landlord, the date that the form was issued. This is the crucial part here. Take notice that the undermentioned warrant will be executed by the bailiff of the court on 11th April 2025 at 10:30 AM. So they were meant to leave on the 12th of March, but they did not. So now they've postponed it by essentially an extra month to the 11th of April, at which point they will be, if required, physically removed by the bailiff. So here you can see the case number, warrant number, claimant name, claimant name, the defendant name, the address at which the bailiffs will attend to remove the nuisance tenant from the property. A possession warrant by itself does not give the county court bailiff authority to use force to evict. However, the landlord or the landlord's agent can authorise the bailiff and the police if necessary to use reasonable force if that becomes necessary. If you have any reason to believe that the bailiff will encounter any difficulties that may perhaps require additional bailiffs, police assistance, please contact the court manager or bailiff manager at the court immediately. This must be a minimum of at least 5 working days before the appointment to avoid postponement. Please indicate that you have done so on the slip below. Right, now, as mentioned, even though you have received this form, you have to still do a little bit more work. So the appointment must be confirmed by completing and returning the tear-off slip below to arrive at the court at least 3 working days before the appointment date. Otherwise, the appointment will be cancelled. You should meet the bailiff outside the premises at the address at the time stated. You should be able to provide him with evidence of your identity. In the case of a warrant for possession, you should meet the bailiff at the address with the support or means to gain entry and to secure the premises against re-entry. If the warrant is for delivery of goods, you must identify the goods and provide for their removal and transport. Some small print here. You can see confirmation of the bailiff's appointment. Here are the details of the landlord. All you have to do is sign it, date it, and send it back to the court. Again, another cover letter, which I'll show you now. So, you've been given the notice of bailiff appointment, which is the EX96. So when you fill out the slip at the bottom, do another cover letter. Just copy this. Just put the court details here. The date. So 31st of March 2025. Dear court manager, here's the claim number. Here's the warrant number. Just put the following: please find enclosed, signed and dated notice of appointment with the bailiff slip for regaining possession of my property. Here's the property address. If required, please forward any correspondence to my home address of, and here are the details of the landlord. Thank you very much. Yours sincerely, the landlord. So once you send that off, your appointment will be, so to speak, set in stone, and you can then hopefully sleep a bit easier, because come that date of the 11th of April, the bailiff will be there and they will remove the tenant. What might happen between the time you send this EX96 cover letter along with the bailiff slip is they may send you a questionnaire to fill out, usually called a risk assessment, asking questions like has the tenant ever been verbally abusive? Has the tenant ever been violent? Are there any pets at the property? So if they do send you a questionnaire, simply just tick the boxes, email it back to the warrant officer, and that could just give them a bit more further information if they need it. But the hard part is done now. You've got your bailiff appointment, and now the tenant cannot escape. There's no way they can force you to go through any more processes or try and delay the eviction any further. They've already done that for months and months and months. So now you're in a position where you're finally going to get your home back. As mentioned, this has been for me, it was a lot of work, a lot of hours, a lot of research. it was quite a bit of work. For you lot out there, the landlords, I really do have sympathy for you, because you know, a lot of people think landlords are, you know, very well off or rich people, and it's not the case a lot of the time. A lot of the case, landlords are working every day. They've got full-time jobs, such as my acquaintance, and it's difficult to try and get by, and it just doesn't seem like the law is in your favour. So you do have my sympathies. I mean, some landlords are unfortunately not great, but most of them are pretty good. Again, even with tenants, you know, I would say most tenants are pretty decent, but unfortunately you do get the ones which are just awful and make life utterly miserable. So you know, I do wish you all the best of luck. I hope these videos, even though, as I said, they are not professionally produced, because I'm not the best at video editing or audio editing, but I do hope the content has hopefully been of use to at least one person, and wish everybody all the best. Take care and goodbye.